Please, Your Lordship. Lordship, I beg to mention item number 14 and number 15, Your Lordship. If Your Lordship can have this matter after 2 weeks, Your Lordship.
It's also a very old matter. Now it's been going on for 4 years.
Personal difficulty, Your
This
Lordship.
is those suspension issue.
Lordship, yes.
If you're not interested, or you feel that you don't have a case,
No, Your Lordship.
you should be straightforward. How many times have you asked what time this is? They are okay. According to you, they are under suspension.
Yes, Your Lordship.
But according to you,
According to me, Lordship,
abandoned.
they have abandoned their service voluntarily.
on premier by petitioner, this is matter after 2 weeks.
Apply, Your Lordship.
On daily list, item number 1.
May it please Your Lordship. Lordship, that is the same issue where Lordship was pleased to give it a save.
I have not yet been able to prepare that order. Some of the parties have not yet filed their written arguments.
So for the state is concerned, Lordship, we have filed, Your Lordship.
Yes, yes, I have noticed that.
So we'll have this
So
after.
Mr. Saran will today is
Today is 23rd, Your Lordship.
23rd.
we'll fix it on 29th.
29, Lordship.
Premier by the parties, this is met on 29th.
1, 2, Your Lordship, same order.
Yes,
Apply, Your Lordship.
3.
1, 2, my
1,
Lordship.
2, Your Lordship. 1, 2, 2,
3 will be the same.
Lordship. Yes. Apply, Your Lordship.
Item number 4.
Yes, what is required here?
Your Lordship, in this matter, respondent 5 were supposed to file their counter affidavit, Your Lordship.
I think we are yet to hear on the issue of impleachment.
Your Lordship, the conducting counsel, Mr. P. Nongbury, is out of station, Your Lordship.
Who has filed the you have filed?
Yes, Lordship, I have filed. In this case, 115 of 2024.
How many respondents are there? 5. Who's appearing for the respondent?
Lordship, in this matter, there was a impleading application
Yes, that
which was substantially heard.
that apart, you see, in the main case, there are 5 respondents.
Yes, sir.
Nobody is appearing on their behalf. 5. One, two, three, 4 are district council.
District Council, Miss Senior Advocate.
Miss, I submitted that the Leonard conducting counsel, Mr. P. Nongbury, is indisposed for the day and has sought
Lordship.
for accommodation.
Your Lordship, actually, we're not praying for time anymore. In this matter, we've already advanced our arguments on the last date.
As far as impleachment is concerned,
Yes, Your Lordship. So,
Who's
we're
the
under
reply?
impression because the impleading application, the petitioner in that application had prayed for time on the last date to bring some connection with regards to the appeal and this instant writ petition. So it's on their part to take steps, Your Lordship, not on our part. And that is for the writ petition, Your Lordship, for the implement to the Your Lordship.
Just a moment.
Russell,
78 order ni wait 78 minta ni tadi ini kan last order juga ini order juga 76 oh man. No, this matter was supposed to be, according to the order, last order, supposed to be fixed for hearing on 7/8. So that was in August.
yes.
So I was not there at on that day. So eventually the case was relisted today. So we are at the stage of hearing of the application then.
Yes, Lordship. If you recall, Your Lordship, the implement application was already heard. We've already advanced arguments. But the petitioner in that impleading application has sought for time.
Who is the petitioner? You. You have sought for time.
They sought for time to bring some documents which will relate this petition with the appeal that we have filed.
Oh yes, now I
If you
recall.
can recall, Your Lordship.
The
Because
which
we're
is
saying that they
pending
have
for-
no locus to even be impleaded in this petition. Because
Yes.
appraise is only for the procedure adopted in inquiry.
So what do you say?
And then I'll be praying for some more time, Lordship.
Lordship, I would object to that, Your Lordship, because the inquiry is again fixed. Your Lordship will be prejudiced if this keeps on going, because we're praying for speedy disposal. And they're not even party under delaying the instant writ petition, Your Lordship.
I thought ni kayo ni ka Miss Case ni Mr. Legal Counsel for the applicant has submitted that has prayed for accommodation on the ground that she is not prepared to be heard in this matter today. The Legal Counsel, Mr. Legal Counsel for the Mr. Legal Counsel for the petitioner, oblique respondent, on the other hand, has raised an objection to the prayer made on the ground that the inquiry against the petitioner, oblique respondent, against the respondent, oblique respondent number 1. Respondent no, is going on, and if there is a delay, it will prejudice his case. This court has noted the submission made, but however, on grounds of on the ground made out by the Legal Counsel for the applicant, the prayer is allowed. This is matter for hearing after 1 week. Now, as far as the main application is concerned, who has to file the
Respondent number 5 is yet to file the affidavit.
only file?
We've been seeking time again and again, Your Lordship.
Mr. Sama, you in this case?
The counsel,
Oh, you
they have filed.
you have file. Mr. Legal Counsel for the respondent number 5 has sought for some time to file the counter affidavit pre-allowed. This is matter for 1 week.
Obliged, Your Lordship.
Item number 5.
File a hearing then. 5 to
5 to 11, Your Lordship.
you're all those
Lordship, yes.
similar issue.
Lordship, yes.
Some for termination,
Lordship, yes.
some for salary.
Then some for the alleged non-payment of salaries. No.
No?
So,
What is, I think this matter has been heard.
yes,
It has been heard, Your Lordship, and there was a submission made that in their place somebody have been appointed.
Yes,
So they are required to file an implement application, and that has already been filed. A notice has been issued. I do not know whether.
we'll be filing affidavit of service, Lordship. Oh.
That is in item number 5. So your implement application has been allowed.
No, Lordship.
Notice has been issued.
Notice has been issued, Lordship.
Notice has been issued.
Yes, ma'am. Notice has been issued, and you have entered appearance today. Do you have any objection? Miss Legal Counsel has submitted that she is on receipt of notice. There is no objection to the implement to the notice receiver to be implemented as party respondent in this case. Have you got a copy of the petition? You got. So are you filing any counter? It is prayed that sometime may be allowed for counter affidavit to be filed, if so required.
Lordship.
Then
For other,
just a minute.
That is 4-5.
Then Lordship, then that miscase 121 of 2024 has to be disposed of, Your Lordship, since they have entered appearance.
yes.
Yes. Accordingly, this case number 121 of 2024 is hereby disposed of.
Number?
So this would be for, this is for item number 5.
I don't know in which.
And what about 6? You are also there, same.
No, for responding.
Then miscase 119 to 24, Your Lordship, that has to be disposed.
Itu kan long ju mo same order. So I think the date the number. Then
In
what
seven,
about
in
7?
item 7.
For other item, Lordship, we will be filing the affidavit of service, Lordship, during the course of the day.
Item 7, itu kan miscase. Then the counsel to the petitioner has submitted that the notice as directed to be issued by this court has been duly served. However, it is prayed that sometime may be allowed for the affidavit of service to be filed. We are allowed. Then 8.
For that also, Lordship, from 7 to 9. Oh, item 8.
Oh, then how many respondents are there?
Item 8.
Number 7, we are applying correspondent to 8.
Item number 7.
Respond.
In this miscase, how many respondents are opposite party are there? You have my dear one. That is no problem.
Item number 8. Oh, sorry. Respondent number 8.
Number 8 and item number 7.
Item number 7. There are only 5 respondents. This is 470. Mister, you just check the records. Sorry.
Lordship, I think he also doesn't know for which because how many offset party also.
You just check the record. We'll convene again when the single bench sits.
I have to check.
Problem why you don't take them why?
Supplementary list, item number 1.
Yes.
Item number 1 and 2. This appeals have come from one judgment, my lord, of a single judge. Number 1 is preferred by the corporation, my lord. Here, my lord, the other respondents are yet to enter appearance, my lord, in number 1.
Are you taking steps?
My lord, we have taken steps through the department. We have already shared the petitions. So they have appeared in the number 2 item. So I believe they must have received. Otherwise, they are here, my lord.
I'm here, Your Worship. I'm submitting the order also.
You are appearing for?
For the 9, 10, 11 in the respondents.
Item number 1.
Yeah.
In item
Yeah,
number
yeah,
1.
wait. Let us look.
Oh, the other people are there.
You are there.
Who is appearing with the respondent?
My lord, actually the petition was filed by us
9, 10, 11.
and there were 3 private respondents. None of the private respondents had contested the writ petition. Now, one of the private respondents in whose favor the contract was awarded, he has filed an appeal and he is represented by my learned friend Ms. Parveen. So far as the aspect of service on the respondents are concerned, I think, my lord, your lordships can take the matter as they have been duly served, because the other respondents, they remained ex parte in the proceeding before the writ court. And otherwise also, my lord.
See, that could be the case, but since, see, this is an appeal filed by the corporation.
Yes.
My lord, number 1 is filed by the corporation.
You are appearing for the corporation.
My lord, I'm appearing for
But
that.
you are appearing for?
I am for the writ petitioner respondent number 1 here.
Okay, so you are respondent number 1.
Yes.
You are the principal respondent.
Principal respondent.
I was the highest. I was the one who was.
Let us confine to one petition at a time. So in this appeal, you are the respondent and you are the appellant.
And
I'm the appellant.
Yes, you are the appellant.
And the others are pro forma respondent.
They are all pro forma respondent, but you have taken steps for issue of.
My lord, we have.
So is that complete or not?
My lord, my friend, she represents, so her clients have received, my lord.
You are representing all?
No, I have between 9, 10, 9, 10, 11.
Okay, so 9, 10, 11. As far as.
Yes.
Are you contesting or you are not?
No, this is they are also.
You're contesting.
I'm contesting. I'm in two.
You are the pro forma respondent.
Yes.
If you're contesting, then you will be
Main respondent.
made respondent, proper respondent. That is as far as 9, 10 and 11 is concerned. What about 2, 3, 4, 5, 6, 7 and 8?
They are only the departmental authorities, my lord. Who?
They may be. They have been, they have been arrayed as pro forma respondent. So which means that notice has to be issued to them. They should receive the notice and come before the court and say we are not interested or we are interested, as has been said by respondent 9, 10, 11. So Ms. Kolni, tell me.
My lord, we have already taken steps, my lord.
Has it been effected?
My lord, I have to take a proper instruction on that regarding the slips or whatever receipts of their receiving of notice, my lord, in that regard.
So we are stuck at that stage then?
My lord, at the very initial stage.
My submission would be, my lord, the appeal is by the corporation, of which, my lord, the pro forma respondents are the authorities. They are in the best know of things, and particularly the pro forma respondent number 3. Against him, my lord, there is a contempt proceeding pending. So it is also not that they don't have any knowledge of it. They are in the knowledge of the things.
We understand that, but until and unless they are represented in court, until and unless they come before this court and say yes, we are here in this case, we wish to be to contest, or we don't wish to contest. That would be, see, until and unless that issue is decided, then there's nothing we can do.
That's absolutely correct, my lord. But what I submit, my lord, the department is itself the appellant.
Exactly.
And in that case, my lord, the pro forma respondents who are the authorities of the department,
Exactly.
they cannot have any claim against the department.
That is
Why they are mixed parties?
That is
up to
that's
the
Why they are arrayed as pro forma respondent? Yes,
My lord, that is what even I was.
that is what you do not know.
My lord,
You are representing the
My lord,
appellant. you do
because
not-
in the writ petition they were make a party, so we were also requested by the registry to make them a party again. Otherwise, my lord, respondent number 2 to 8 are the appellant
They
officers
are all
only.
your officials.
My
They are
lord.
all your
So
official
my lord,
officials.
9, 10 and 11 she is already present, so all the parties are present, my lord.
What tell about the official respondents. They are all your officials.
My lord,
Then
yes.
why they are as a pro forma respondent?
Because they were arrayed as party in the writ
Are
petition,
they
my
siding
lord.
with the appellant?
No, my lord.
Then?
Yeah, they're signing with that.
No.
No.
Okay.
It's very confusing.
Therefore, my lord, my submission is that the service has to be deemed as complete.
Complete, my lord.
How can you say that?
Because, my lord, 2 to 8 are from the department.
We understand.
9,
we
10,
understand.
11
But are you representing them?
My lord, these are the appellant, my lord. These are the appellant officers only, my lord.
Yes, they are appellants officer, no doubt. But the point is, you have read them as respondent, pro forma respondent.
My lord, yes.
So, as I was saying earlier, see, that process has to be, we have to bring a closure to that process. Then from there we start.
My lord, I understood what lordship is, what is falling from a lordship.
What you could do is you could
Strike
get
them
them,
out.
strike them out.
My lord, that will be proper. Otherwise, my lordship allowed me to make a proper correction of the cause title.
That is the best way of
My
doing
lord,
it.
we will do correction, my lord.
Only
I
thing is
believe 2 to 8 may not be required because we are the appellant officers, so we'll do the correction, lordship.
Very strange
Yes,
situation.
What was the position before the writ court?
My lord, the writ court, they did not appear.
No,
Only-
those official respondents, they were respondents because
My lord, we were
Yes, they were
respondents.
respondents and
were
they filed affidavit. Now, the appeal, in my understanding, will-
official respondents filed affidavit.
one of
Affidavit, and then or
one official respondent filed an affidavit that on behalf of the corporation.
then how come they are now on the different side then?
That is very strange, my lord. In my understanding, they ought to have been joined as appellants in the case.
It has been pointed out at the very first instance.
On the last occasion, the
Can they? I do not know. That is something very.
My lord, I'll make correction.
The respondents in
I
the
believe
writ petition, they cannot become pro forma respondents here.
I'll make correction, my lord.
You do that.
Yes, my lord, that will
Because
clear
very
out the
it
entire
might,
issue.
create a
My lord.
very confusing situation
lord.
later.
I'll make correction.
Well, my
Lordship, kindly
respectful
permits me to
submission
make
is that
correction.
your lordships can pass an order saying that the pro forma respondents number 2 to 8, they are struck off from the array of
Until
parties.
unless they come with that prayer, why do we do this? Let them do.
My lord, I'm making a prayer to correct the cause title. Otherwise, the lordship can also pass. It will sort out the entire issue one or the other way, my lord.
You file an application for striking off there.
My lord, then I'll do that. I'll do that.
Miss Arkulni, the counsel appearing for the appellant has submitted that the notice upon the respondent 9, 10 and pro forma respondent 9, 10 and 11 has been duly affected. The said respondents are also duly represented by Miss Leonard Counsel, who has submitted that this respondent would choose to contest this appeal. Accordingly, they are now read as proper respondent. Oh, they are also this is why would you? Very confusing. Let me leave it at that and see. Another submission of Ms. Conley is that an application to strike off the name of
2 to 8, my lord. Pro forma respondent.
2 to 8 respectively may be allowed to be filed. May be allowed to be filed. Pray allowed. This is matter of 1 week.
My lord, 2 weeks. I'm praying for 2 weeks.
Well, 2 weeks will be too long a
Is there
time, my
any
lord.
interim order here?
Well, yes, my lord. That is the reason.
interim here.
No,
That is there is an interim order saying that the work will
Yes,
proceed at the risk and cost of the bidder.
in the
Now,
meantime, I
now,
can sort of
That is the last order.
now our anxiety is that, my lord, we are successful writ petitioners. Now, if the work order continues like this, my lord, in this situation, my lord, at one point of time, the entire purpose of the writ petition will become infructuous.
My lord,
So
I'm praying for 2
the
weeks.
contempt proceedings are listed on 27th, my lord, and
That
so
is before the
that is before the honourable single judge. Therefore, my lord,
Contempt is not even been taken up because once the appeal is
even
taken
the
up,
issue of
contempt is not
contempt is
even taken
also
up by the
under
single judge.
consideration here.
yes.
So it will not
Now,
Since an appeal has been filed,
yes. Now, my humble and respectful submission is this, my lord. Since it's a technical aspect, my lord, on which, my lord, it is stuck up as regards the performer respondents, they can file an application by next week.
That's
my lord.
what I said. That's what
My
I
lord,
said.
it will be difficult, my lord. If lordship give me 1 week time, it will not most likely happen. Will come, we might have to pay for additional time. So my lord, 2 weeks will come up with affidavit. The petition will be filed within the time period, my lord. So lordship can directly pass an order on that day. So my lord, it will just waste the time of lordship. my
In
lord.
that case, my lord, your lordship may reconsider the continuation of the interim order. Because they are
That
in.
is all. You see, that is already there. That's already there.
No, that's why, my lord, I am renewing my
Look-
submission.
Look at the order. What does it say?
The interim order says that the work may proceed at the risk and cost of the successful bidder. So now if the
wants to stay of the single bench order.
Yeah,
Single bench
look at
order has
par-
interfered with the settlement, isn't it?
yes.
So this is a kind of order which basically, in effect, it's a stay, allowing the bidder to
Yes.
continue.
So therefore our anxiety, my lord, if this continues, my lord, this arrangement continues, my lord, soon the work itself may be over and the entire purpose of the writ petition will be infructuous. It is their lapse, my lord. They ought to have joined the performer respondents as appellants, my lord. Now they cannot say that for curing the defects and all, we need so long a time.
Anyway, we'll ensure that on the next date, the matter will be finally.
My
on.
lord.
So we'll list this matter on. Give a date.
My lord, after if your lordship is passing it over for 2 weeks, my lord, then on 9th or 2nd of September, my lord.
Yes, Ms. Kun. Second.
My lord, if I'm getting 2 weeks time, my lord, I'm okay with any date, my lord. I'll inform the senior councillors in the meantime. My lord,
It's only about filing an application, my lord.
Today is
My lord, second,
Today is 23rd.
1.
My lord, second will be 1 week, my lord. So 9th will be
Ninth.
the 9th.
Are you okay with 9?
Well, 9th, otherwise date is okay, my lord, but then
If court is allowing 2 weeks, then it will go to 9th. It cannot be on 2nd.
yes.
This is matter on 9th.
Item number 2.
Well, item number 2, I think your lordship can pick up. It's up to you.
What is the
Lordship, here also, I have made them pro forma defendants, those parties, Lordship, and we did not put into notice.
Just a moment.
Then your appeal will go for not taking steps.
I'll take steps. There was, by the last order, there was nothing like that.
It's up to you.
By the last order, there was nothing regarding steps taken, Lordship.
Oh, listen. Yeah, this case. This was.
These appeals are
Yes,
not
Miss
admitted.
Kuni.
This appeal was not
No,
admitted.
The first one?
First one only, my lord, the observation.
Was there any order admitting the appeal?
No,
Nothing.
You should have pointed out all those things.
Well, actually, my lord, if I may say so, my lord, the order got uploaded at a much later point of time. Although it was fixed on 25th of July,
After
the order
15 days.
after the order got uploaded at a much later point of
Much
time.
later point of time.
So that's why, my lord, we were also otherwise helpless. We could not even make a mention before the court because the appropriate bench was not available.
And for us also that interim, they said on your own risk. We cannot carry the work because that's the technical order that we won't take the risk of
You
carrying.
give up the work, then if
No,
you
why
do not
should-
want to carry on, do not want
It's
to take
not
the
that. It's not. It's on our own risk. It is not that. I'm not talking about that. It says it's your own risk. First,
Yes,
being a
naturally.
good citizen, I have to fight the case first. Then get an order and do it.
No, if you do not want to carry on with the work,
I want to carry on. But that order doesn't reflect me or give me a permission. It only says at your own risk.
If you are confident of your case, then
No. It's nothing like that.
do that. Anyway, I think we have to make some correction in the order on the first case. So, since much water has flown, so the appeal would be considered. Okay, Ms. Kundi, you file your application. Then on that day we'll.
And on 9th, your lordship may consider admission of the appeal. The appeals may be admitted, I mean listed for admission hearing.
You should have told us before we could detect that there is
Lordship.
no order admitting.
Yes, there is no order admitting the appeal.
Yes.
You should have pointed it out. You did not point it out.
Since both the matters
If the court asks you. Anyway, it's all right.
And in our case also, Lordship,
Just a moment. Where is your memo of appeal?
তো এটা স্টেপস লগইন এন্ড লগইন কোন চ্যালেঞ্জ করবে এটা চ্যালেঞ্জ করবে এখন ইউ আর দ্য ফ্যামিলি মেম্বারস অল
these people are there.
Second case is appeal by the
successful bidder. There also, my lord, if I may say so, subject to correction by my friend, the array of parties is, in my understanding, my lord, it's not proper. Because the
that is for her to
If-
decide for us.
yes.
See, madam.
Yes.
If I recall correctly, and looking at the other case that has been disposed of, you had entered appearance on behalf of the respondent number 8, 9, and 10.
10, yes.
Isn't it? Or 9, 10, 11, whatever the case may be.
9, 10.
It appears that in this case you are the appellant, but those respondents are those parties whom you are appearing. Now they are arrayed as respondent.
There is an apparent clash of interest.
Is there any?
No, I couldn't get it, Lordship.
You see, you are, in the other case,
Yes.
you had entered appearance
Yes.
on behalf of the appellant herein and two others, 9, 10, 11.
Yes.
Respondent 9, 10, 11, the other case.
Yes.
Now you are the appellant here.
Yes.
That is, you were respondent number 9 in the other case.
Yes.
In the writ petition.
No, no.
In the
In the appeal.
Yes.
In appeal.
Yes.
Again, in this appeal, it appears that you have also arrayed the respondent number 10 and 11 there in the first appeal as
As a respondent here.
No, I did not give my appearance here in this. Till now, I did not get service. I did not file my wakalatnama till now. No, Lordship.
which case? In where?
In this one. In one. In one. কি কথা কৰে তই?
কলি দেখুন মাত্র
Hey, no, it's not that. I'm saying about my case. Surajit, I'm saying about my case. They are putting it and asking me 9, 10, 11, you are this case, that case. I did not say. Why am I making? They did not understand.
My lord, I being the respondent, my lord, I am
No, Lordship, what
only
happens here?
getting to see all these things, my lord.
Can you understand the point? You compare the other the other appeal with this present appeal. That is up to you. That is up to you. Finally, we will pass an effective order
Yes,
in that regard,
Lordship.
whether you make your submission or not. But the only thing is, at this point of time, the court would just caution you as far as your stand is concerned. In the other case, you had appeared on behalf of 3 respondents.
No, only one.
First you say 3, now you say
No,
one.
Lordship, that's what I was not understanding. This is only one. I'm following Taibin Warjuri. And here I am the appellant.
We have to get back to the first case then.
My lord, another thing I must
It's a mess. See, we do not.
Another thing I must point out, my lord. We had a caveat in the first appeal, of course, in respect of both the appeals. On the first date, although we said that we appeared on caveat, my lord, the caveat is also yet to be discharged.
Not discharged.
Yes.
Lithogra first.
Lordship, may I tell?
Just one. We will go by the records. We'll have to- See, Miss, let me tell you. This is the first case. Miss Kohli is appearing for the appellant. The principal respondent is represented by him. Now, as far as the former respondent is concerned, apart from 1, 2, 3, 4 till 8, 9, 10 and 11, 9, 10, 11. Let me go by name. 9 is Taibin Wajri. You say you are appearing for him. You are appearing for him. 10 is Connie F. Saukmi. You're appearing for her
No. In the first case,
in the first case.
Lordship, may I see the records? No, because there's no Wakalatnama, I think.
No.
I'm not
You-
appearing.
you
I'm
have
not
to file your
appearing.
Wakalatnama,
No,
doubt.
because they,
You see, you are making a submission in court.
Lordship. No,
If-
I thought
if-
in this
if-
case, that's what I
if
said.
power is to be
Lordship. I'm not appearing for them, only for Tywin.
My lord, we have already taken steps upon those 3 contractors, the respondent, they have already received. So I believe my friend, if she is appearing, the clients will certainly speak to them. They've already taken steps upon
Yeah,
it.
they did not speak to me.
Okay, so fine.
that can be
That
clear.
is the confusion.
My
there.
lord.
You see, now,
My
if the second case is not there, we would have gone on a very wrong presumption.
Yes.
Pomno otoka ayo. Just a moment. Okay, so that first appeal is correct.
And in fact, my lord, in the first order, there is also no order order regarding issue of notice.
Notices. This
on
is the
on
main
any of
reason.
the-
So we are on that only.
Yeah.
Miss
We
Colvin,
have found it out. There's nothing.
Nothing.
We are surprised.
yes, I think we go back to the first case. As pointed out by my brother, it appears that steps have not been taken. You said you have taken steps, but there is no office note.
There is also not an order, not even an order from the honorable court
Directing them
directing them to
to take
take
is no
steps.
order.
for service of notice. Where is that order?
There's no order.
Yes, it's true, my lord. It's true. There is no order.
So it means without any order, you can take steps whenever you want. So whenever we like. Come this way.
That is the thing what I'm saying.
My lord.
Before taking steps, you require order.
My lord, there should.
isn't it?
My lord.
Was there any order passed in this matter? Have you checked it?
No, my lord, it wasn't. There is no order to this
So
effect.
you
My
have
lord.
acted mechanically, that we have filed a case and then we need to take
My lord,
steps.
if I stand correctly, my lord, there was orally, like, my lord, we have that impression that we have to take steps upon the other respondent. So, my lord, that is the procedure. So we have actually taken, my lord, on our own, my lord. However, it's true there is no order to the effect that we have to take steps. So we were just following the procedure which we do generally do, my lord.
Yeah, I think I'm. You see, I have to admit that I'm also in the wrong. I was party to this order.
My lord, yes.
We should have
My lord, my apology, my lord. Lordship was part of the bench.
Yes. So we'll do one thing.
My lord, then an order can be passed.
You file your application.
My lord, for deletion of.
for deletion. Then on the 9, we will take up the matter of the issue of caveat.
My lord,
Apart from caveat, then we will also direct you to take steps if required.
on the next occasion, my lord.
So that would be proper.
My lord.
So as far as you're concerned, if you say that you are appearing, then you have to await formal notice to be issued to you. No, on the next date, then we'll,
Observation accordingly, Aglo.
but even if you you say that you have appeared on behalf of the respondent
I'm
one
only
night,
appearing on behalf of the appellant. This is why I'm challenging this in the.
we are talking about the first case.
Oh, no, I'm not appearing. That's it. I'll be appearing only for that time in my appellant. Let the notice go, Lordship.
I think we have to. Katuka, yun yung katuka first case mo. First. We'll dictate the order again, as far as the first case is concerned.
My lord.
Ms. Argoni, learned counsel for the appellant, has submitted that the appellant may be allowed to file an application for deletion of the names of respondent 1 to 8 respectively from these
2 to
proceedings.
8.
Pro forma respondent 2 to 8 from these proceedings. Pray allowed. So that will be the That will be number 1.
Madam.
Now, here you are the appellant.
Number 2.
So, this is matter on 9th. Now, as far as here also, notice has not been issued. So, whether you have anti-appearance or not, whether you take
Well,
notice.
I was on caveat. That's why I wanted.
Okay.
I was on caveat.
Oh. Yeah. Should we do the same way or would you in this?
এই দুইটা কাট
এটা কাটিব পাৰি নাই
অ্যাপ্লিকেশন দিয়ে দুইটা কাটিবি না হলে গন্ডগোল হয়ে গেল
May I pray, Lordship, 10 and 11 will be struck off in my petition, in my appeal.
Then you file an application.
You file an application
Similar.
just like that.
I think we'll take up this matter also on the 9th.
On 9th.
We'll pass a common order kind of.
Yeah, the same judgment.
Yes, because it appears.
Yes.
I mean, it's from the same judgment. Mr. Letter Counsel for the appellant has submitted that he may be allowed to strike off the names of respondent, pro forma respondent, 10 and 11 from these proceedings, for which an appropriate application in this regard may be allowed to be filed. Pray allowed. As prayed for, this is matter on 9th.
And interim will continue.
Well, your Lordship may just observe that on 9th it will be listed for admission. Otherwise, my Lord,
again it will be problem.
there may
This is matter on for admission.
And Lordship,
both the cases.
earlier order will continue.
No, that is not limited to this date. That is
Yes.
already
The
there.
order will continue.
Only both the orders. Both the matters will come for admission, my Lord. That your Lordship may indicate.
Yes, that will.
The whole thing happened because there was no order last time. That's why I was thinking, how come today it came in orders?
Oblige, my Lord.
Oblige, Lordship.
The release item number 1.
This is an appeal filed against the order passed by the learned single judge, my lord. After filing of this appeal, they filed an affidavit without raising the challenge to the very maintainability of the writ appeal, my lord. On the ground that, my lord, this is a customs matter and there is a monetary limit for filing an appeal, my lord. They are referring to certain circular of the department.
This is writ appeal, isn't it?
This is writ appeal, my lord.
Writ appeal, where is that thing, that restriction? About the monetary jurisdiction?
My lord, there is a general instruction which they've relied on.
Instruction by?
By the department.
My lord.
A 15 and 16, page 15 16.
Of your?
Affidavit in opposition, affidavit in objection.
Where is your?
Yes, the instruction.
Day before yesterday they served a copy, my lord.
Yes, so
appeal is barred by monetary limit fixed by the CBIC, dated 2/11/23, wherein monetary limit for
High Court
filing
is
appeal
1 crore.
in High Court is only 1 crore. Here matter is 60 lakhs revenue refund. Involved is 60 lakhs. So it is below the monetary limit, and Supreme Court has summarily dismissed at page 17, Annexure B.
Will it bind the writ court, Mr.?
My lord, that is, I want to.
Just verify it. Let there be.
My lord, I want to place a reply to this.
Normal jurisdiction and extraordinary jurisdiction are two different. So please.
My lord, that is my
your
submission.
mind from there.
And moreover, my lord, this is issued under section 131
You are
of the Customs
fixing
Act.
jurisdiction.
My lord, they are raising objection. I am the appellant, my lord.
Read jurisdiction, even the apex code monetary thing. That is
They are
something
saying,
very-
my lord, they are the respondent, they have raised this
No, at
objection.
least please clarify on that, those things, please.
So, my lord, in the meantime, I'll file a response to this, my lord.
We have to look at, we have to examine this. How long?
10 days time. I'll file a reply to this.
Dr. N. Musika, Leonard.
On the question of maintainability. Your reply
A reply to this, my lord, their affidavit.
Yes, you replied. We file a rejoinder to this. Dr. N. Musika, Leonard, DSGI, has submitted that he may be allowed to file a reply to the affidavit in opposition filed with the respondent. Filed with the respondent. On preamble, same is allowed. This is matter on after 2 weeks. 2 weeks.
Departure.
Item number 7.
Maybe you have to go 5. And maybe. We'll go back to item number 5.
Yes, Lordship. Lordship, he has filed implement application in item number 5 to 9. Lordship. So we'll have to see who will appear for the newly implemented respondent.
Your Lordship, I'll be appealing for the already my senior.
He's appearing for the new teacher.
Yeah, that's what, that is.
Application sought for implementing the principle and the
Your Lordship, this copy of the petition may be given. Your Lordship, this copy is given and then it is not complete. Whatever I got the copy and it is not the complete.
You have filed this application for implement.
Yes.
But why have you arrayed all the respondents here? So these are the, it would mean that all these respondents are to be impleted.
All the respondent has to be implemented.
They have not been impleted. These are not impleted. Show him a copy of that petition.
No, applicant. The applicant is seeking for the implement, Lordship.
He is seeking implement of only respondent 6 here.
Respondent number 6.
There's Azhar Rahman.
Yeah.
But what about this 1, 2, 3? They are already there in the
item 5.
Earlier in the main petition.
Yeah.
Let me just check.
Azhar Rahman, show me your petition.
Yes. See, you go to the main petition and you find that so and so petitioner and versus 1, 2, 3, 4 and 5, they are all state respondent.
State respondent.
No, not state respondent. 4 is the principal.
Yes.
Who's appearing for the principal? 4 and 5 are principal and managing committee.
Lordship.
You are appearing for 4 and 5. Okay.
Lordship, in the original writ petition, Lordship, there are 5 respondents.
5 respondents.
And he is seeking implement of this applicant
6.
Item 6, Azhar Rahman, to be implemented as respondent number 6.
Okay. As respondent number 6.
As respondent number 6. Where's applicant?
Okay, so we'll leave it at that. Now.
What is his name?
Mr. Deputat?
I'll be filing my work now.
You'll be appearing.
He'll be appearing.
So you accept notice and you'll file your or.
The petition may be given to me.
Yes, he'll give to you.
All the pieces not here.
Please check carefully and.
Will serve, which will serve copy.
Yes, Mr. Secretary, anything as far as you are concerned?
This TSUO were not sought to be implemented. The subsequent application I was informed that the applicant is seeking for implement of the principal in person as well as the retired TSUO. On the occasion I 1 year back, they sought for implementing of this principal and the STSUO. This was not rejected at the now they have again sought for implementation. For that matter,
No, but you're in the main petition. You're appearing for principal. Yes.
Now what happened is subsequent application P5, my friend 5, they are seeking for implementation of not only the new teacher,
only new teacher,
but also sought for implementing the principal and the retired TSU.
Where is there's no amendment to that?
The subsequent application. This case number 120 of 2024.
120. 120.
121 or 120?
120.
Where is 120?
This one, no? Yes, item number
This
5.
120 is.
I'm present item number 5.
Item number 6.
Oh, this is item number 7.
Item number 7. Item number 10.
Oh, yeah. Okay.
Number 6 in 7. 6 is the principal.
Okay.
7 is the retired.
This one, no? Item number 10.
Okay, just so that we'll not be confused. Can we go item wise?
We'll go one by one, Lordship. One by one.
Let us clarify first item number 5, Your Lordship.
So item number 5. You have nothing to say as far as item number 5 is concerned. So we'll take it that Mr. Debnard has accept notice. He will file his power, and you will file your response if required.
File my power.
Mr. Mr. R. Debnard, Letter Counsel, has submitted that he is instructed to accept notice on behalf of the on behalf of the respondent 6. For which this application for impleadment has been filed. However, the Letter Counsel would submit that he would require some time to file the power and to get specific instruction in this regard.
Copy of the petition may be given to me.
That
he will give.
That is got to be reflected in the order.
Once the court says that you have accepted notice, means it goes, it stands, it is automatically understood that you will get a copy of that. As preferred, we'll list it after 1 week. As preferred, this is matter after 1 week. That is
item number 5.
Now 6.
Item 5.
Huh?
You have to file some reply.
What reply? You're already there. You're the teacher now, so you ought to be impleaded. It's an old matter. We should not delay unnecessarily. How to come? How come? Mean list the matter after 1 week.
Yeah.
Okay, now.
Item number 6.
Item number 6.
Now, item number 6, there are 5 respondents, and he is seeking impleadment of the applicant as respondent number 6.
Are you appearing here, Mr. Devnath? You're not.
Item number 6.
No. You'll be appearing here.
By name Nur Alam. Nur Alam.
Have you been instructed to?
Just 5 meters. This altogether there is 5 numbers.
Just a moment. Be sure.
Item number 6.
Mr. Kharmi has, given you a hint. You have to whether this person Nur Alam Chaudhry has instructed you to take step or to accept notice. You know him.
I don't know him, but
Okay. We'll accept you. So this will be also same order.
Same order. This is next.
So Mr. Debra has
application.
Okay, now we go to item number 7.
Item number 7. This one, sir? Yes. Item number 7.
Item number 7. You have sought to implead 3 new respondents.
6 to 8.
6 to 8.
And 5 and 6 might not.
Yes, sir. How many respondents you want to implead here?
Only respondent 8.
He is already a party, no?
Yes. 7 is a retired person.
How many
Now
we are seeking to implead here?
these two gentlemen.
Only one, no?
Only one, sir. Regarding this impleadment, remove the application 1 year time to implead this very writ petition. That was rejected by this order. Now again they are filing this court. Because of the matter, we give me 10 days time. We file a short course to satisfy that they are not necessary.
I have given 1 week, 1 week's time to.
How many?
No, that's true. Only one, sir. 1 week will be enough for you.
Full. Then one.
Because you see, I've fixed the date, after 1 week. After 1 week, it may be on the 8th day or 9th or 10th day. It could be on the 11th day. So, you take a chances. Mr. Devnath, here you're appearing. Mr. R. Devnath and the counsel has accepted notice on behalf of the respondent number 8, who is sought to be impleaded herein as such respondent. As far as respondent 6 and 7 are concerned, Mr. For both 6 and 7, Mr. H.L. Sangrisul, learned senior counsel. But have you appeared for them earlier?
Yes. Madam, number 6 I appeared. Now number 7, Madam, he retired, no longer officer. So instruction comes over to represent.
Okay. Mr. H.L. Sangrisul, learned senior counsel, has also submitted that he is instructed to appear on behalf of such respondent. However, he has sought some time to file a response to this application. As prayed for, this is matter to 1 week. So that is 7.
7.
Then we go to 8.
Item 8.
What about 8?
Item 8 also for impleadment as respondent number 6.
Only
one.
So you are not concerned.
Only one.
Same order, 8.
This one. Next.
Then 9.
Respondent number 7. Show me name. This one. Yeah. And only one. Here
Only one, sir.
Substitute.
Yes, sir. Only one.
So 9.
9 as for implement as respondent number 7.
Only 7.
Only respondent number 7.
The same order.
Number 4. This one number 4. Retired person is in.
Already implemented, Lord.
Oh.
Respondent number 4. Retired.
No, not, you see, he has not been impleaded.
No, already implemented.
Huh?
Already a party, Lord.
This number 4.
Number 4, already a party. He's not seeking. He's already a party. Now only one respondent number 7 is seeking.
Okay.
Impleadment.
That is 9.
Yes.
Then 10.
Others there is no impleadment application. Only 5 to 9.
Only 5 to 9.
Yes.
So 10 and 11.
10, 11 same.
This is matter to 1 week. When there are so many applications dealing especially with the same subject matter, it becomes very difficult because there are always chances of overlapping, chances of repetition, so on and so forth.
Item number 12.
My lord, the respondents have completed the argument, and on the last day, the petitioners crave leave to reply, and it is fixed today for their reply.
May it please your lordship. Liberty may be given your lordship to file a brief synopsis of written argument, your lordship. 2 weeks time may be given, your lordship.
But you have not replied.
Sorry, your lordship.
This today is supposed is fixed for your.
Your lordship, the argument has already been concluded, your lordship.
Oh.
Okay.
So you're not responding to their.
No, Your Lordship. We'll be filing it.
So only you have to file your written argument.
If they are filing, then we'll also file our synopsis, my lord, the summary.
That'll be much better.
Yes.
Ms. Legal Counsel, appearing on behalf of the petitioner, CBI, has submitted that the argument on their part is complete and has prayed for some time to file a written synopsis of the argument. Similarly, I'll see all the respondents.
Yes, all the respondents.
Similarly, the respective counsel for the respondents herein have also sought for time to file written argument in this matter. On submission date, same is allowed. This is matter up to 2 weeks.
2 weeks, madam.
I'll give you enough time.
My lord, obliged.
Much obliged.
Item number 13.
This matter was fixed for written argument, filing of the written argument. The petitioner has already filed, my lord. The respondent was
Only respondent 4 is to file.
I'm also placing the judgments also, my lord. Last time I have said that few judgments I will be relying. So I'm filing a fresh written argument itself, my lord. Fresh means the written argument enclosing the judgments, my lord.
You are for?
I'm for a district council, my lord.
Respondent 1 and 2.
Oh yes, my lord.
So how soon?
Right now, my lord, I'm supplying it, my lord.
Mr. Asdep, letter counsel for the respondent 4 has submitted that the written argument on behalf of the respondent 4 has been filed today. Mr. Day, you have already filed earlier.
Yes, my lord. Only the I am enclosing the
I understand that.
Yes.
So
I'm giving this.
not necessary to be recorded.
Yeah, it's not needed, my lord.
And you have filed.
I have filed.
Accordingly, this matter is now reserved for judgment.